Hello, fellow patriots. This is Matt Brown. I am the Zone 7 Sergeant at Arms, and I am going to do a brief video on Article 35, use of force, justification for use of force. I did send Matt out a PowerPoint presentation with Article 35, all listed in there, so you guys can, when he disseminates that to you, you can go by, page by page and read it. I also sent a list from Article 230 or 265, which is the list of weapons New York considers legal and illegal. Good to know. So instead of just reading word for word everything that I already put in the PowerPoint presentation, I trust that you guys can read and understand most of that stuff. What I am going to do, though, is I'm going to discuss the most important parts, and I'm going to hit on the legalese. There's a lot of legal terms in here that most of us don't use every day and would have no reason to. But it's important that we understand them because we're going to have to know what they are if we ever come across a case or a situation where we need to use physical force or deadly physical force. The better you can articulate the reason why you did what you did, the better off you're going to be in court. There's a big difference between saying, this person broke into my home, he had a weapon, I feared for my life, my family was upstairs, I had no choice but to fire my weapon in order to stop the threat, and that's how we got to this point. Or saying, yeah, this jackass broke into my house, so I fucking blew him away. Which one do you want a jury to hear? So it's important that both scenarios are the same outcomes, but the way you articulate it is going to play a big role in how the jury sees you. So if you can articulate, you feared for your life, you felt there was no other choice, you were protecting your family, those things are important. I just blew the guy away because he came into my house is not going to look like you feared for your life. It's going to look like you were just waiting for somebody to come by so you could shoot him. And that is never going to fly with a jury. So let me go over some of this stuff. I'm going to go over each section, but I'm not going to read each section word for word. I'm just going to hit the highlights, and I'm going to hit the words that are going to be probably, the legalese terms. I'm going to give you the layman's terms so that we can easily understand what we are looking at and what we need to understand. And some of this, I'm going to have you guys yourself look up the words and definitions so that you understand and know them. All right, so 3505. Unless otherwise limited by the ensuing provisions of this article defining justifiable use of physical force, conduct which would otherwise constitute an offense is justifiable and not criminal when. So what they're saying is you can't go around beating people up. That's using physical force in a way that it's not legal. But if you are using it in a manner that's described in here, then it is justifiable and not criminal. Such conduct is required or authorized by law or by judicial decree, or is performed by a public servant in the reasonable exercise of his official powers, duties, or functions. Now, that mainly applies to police and peace officers, sometimes to security officers, and sometimes the public. But if it's a public servant that they're referring to, that's always going to be somebody who is a law enforcement officer. Now, such conduct is necessary as an emergency measure to avoid an imminent public or private injury, which is about to occur by reason of situation occasioned or developed through no fault of the actor, which means you didn't start, it's not your fault, which is such gravity according to ordinary standards of intelligence and morality. So the average person would look at this and say, yes, this is rational, this makes sense to me. That the desirability and urgency of avoiding such injury clearly outweigh the desirability of avoiding the injury sought to be prevented by the statute defining the offense in the issue. The necessity and justifiability of such conduct may not rest upon considerations pertaining only to morality and advisability of the statute. Either it is general application or with respect to its application to a particular class of cases arising thereunder. Whenever evidence relating to the defense of justification under the subdivision is offered by the defendant, the court shall rule as a matter of law when the claimed facts and circumstances would, if established, constitute a defense. What does that mean? That means the rest of what I'm going to go over in section 35, Article 35, if you follow these guidelines, you're acting within the law. And a judge and a jury and law enforcement will be on your side because you have, based on New York state law, justification that allowed you to use the amount of force you used, providing you did it correctly and followed these guidelines. So that's what that's saying. You are completely covered criminally if you follow the guidelines listed in penal law, section 35. So the use of physical force is justifiable and not criminal if it's used under the following circumstances. A parent, guardian, or other entrusted person who is in charge of or in care of supervision of a person under the age of 21, or an incompetent person, a teacher or other person entrusted with the care and supervision of a person under the age of 21 for special purpose may use physical force, but not deadly physical force, upon such person when and to the extent that it is reasonably believed is necessary to maintain discipline or promote the welfare of such person. So, if you are a parent, or if you are a guardian, be it a grandparent, an aunt, an uncle, a relative, foster parent, if you're in charge of somebody under the age of 21, you may use physical force for discipline and or to prevent them from hurting themselves or someone else more so than you would be in using your physical force. So the idea is to maintain discipline or promote the welfare of such person. So kind of the lesser of two evils. If they're going to hurt themselves or hurt somebody and you spank them, that's justifiable. A warden or other authorized official of a jail, prison, or correctional institution in order to maintain discipline, such physical force is authorized by the correction law. So New York State correction law says that the warden and the corrections officers may use physical force to keep the inmates in line. It doesn't really apply to us, but these are the people that are allowed to use physical force without getting in trouble. A person responsible for the maintenance of order and common carrier of passengers or person acting under his direction may use physical force. So what this is for like bus drivers, taxi drivers, limo drivers, school bus drivers. Now, under this particular section, you are allowed to use deadly physical force only when he reasonably believes it is necessary to prevent death or serious physical injury to thwart such results. So if you can reasonably ascertain that somebody on your bus is going to receive serious physical injury, meaning, a protracted, permanent, life-altering injury, a black eye is not going to be considered serious physical injury. Gouged out eye, where you're going to be blind, that is a serious physical injury. So to prevent that or death, you may use deadly physical force to prevent that. A person acting under a reasonable belief that another person is about to commit suicide or inflict serious physical injury upon himself may use physical force upon person to the extent that he reasonably believes is necessary to thwart such result. So, what that means is, if somebody is attempting suicide, again, we're going to go with the lesser of two evils. We can use physical force to stop them from killing themselves. We can't use deadly physical force. That wouldn't make sense. You don't want to kill somebody who's trying to kill themselves. That kind of negates the whole. But if you have to use physical force in order to stop them from killing themselves, then you may do that. That is authorized under the law. If you have to injure them, it's better to be injured than to be dead. So that is authorized in order to prevent a suicide. So if someone's about to jump off the building and you grab them by the shirt and pull them back and they fall down and they break their collarbone, that's okay. They're alive. They're not seriously hurt. The collarbone will heal. A duly licensed physician or person acting under a physician's direction may use physical force for the purpose of administering a recognized form of treatment which he or she reasonably believes to be adapted to promoting the physical or mental health of a patient. So again, that applies to doctors, licensed doctors, nurses, healthcare facility places, mental health facilities, so on and so forth. Also really doesn't apply to us. A person may, pursuant to the ensuing provisions of this article, use physical force upon another person in self-defense, this pertains to us now, in self-defense or defense of a third person. Another person. Doesn't have to be a third person. What that means is any other person. If there's you and you see two guys trying to attack, three girls, that's still the same. It's still the same definition. You can protect them. You can defend them against the attacker. So it's in defense of a third person or in defense of premises or in order to prevent larceny of or criminal mischief to property or in order to effect the arrest or prevent an escape from custody. Whenever a person is authorized by such provision to use deadly physical force in any given circumstances, nothing contained in this or any other such provision may be deemed to negate or qualify such authorization. So again, what does that mean? You can protect the premises. You can use physical force to protect the premises from a larceny or criminal mischief. Larceny is theft. Criminal mischief is damage to property, graffiti, breaking light bulbs, anything that damages the property is criminal mischief. And you can use you can use physical force to stop that. You cannot use deadly physical force. Now, whenever a person is authorized by any such provisions to use deadly physical force in any given circumstance, nothing contained in and or other provision may be deemed to negate or qualify such authorization, which would apply to mainly police officers. They have a higher level of the force continuum, as it pertains to them and to us, is different. They can use force plus one. We cannot. We have to match force with force. But if we are authorized, let's say we're an armed security officer in a federal building, which I was at one point, I was authorized to shoot on site without question. If you breached the perimeter of this property, then you took your life in your own hands. That was federal law. Now, Section 3515 is going to be something that we really are going to want to focus on. A person may, subject to the provisions of subdivision 2, use physical force upon another person when and to the extent he or she reasonably believes to be necessary to defend himself, herself, or a third person from what he or she reasonably believes to be the imminent use of unlawful physical force by such other person, unless the latter's conduct was provoked by the actor with intent to cause physical injury to another person, or the actor was the initial aggressor, except that in such case, then use of physical force is nevertheless justifiable if the actor has withdrawn from the encounter and effectively communicated such withdrawal to such other person, but the latter persists in continuing the incident and uses threatened imminent physical force. What does that mean? I get in a bar fight. I get my ass kicked. I say, okay, I quit. You win. I'm out of here. I walk away. Go to my car. You chase me out into the parking lot and you beat me up again. Now you are the criminal. Even though I started the fight, once I gave up, once I walked away, you were no longer in danger. Once you came after me, you became the aggressor because you weren't in any danger. I had made it clear that I gave up and you won and I'm out of here. So I turn and walk away. If you come after me, then you are now the aggressor. You are now the criminal. So deadly physical force physical force is not allowed after you're no longer in any danger. If somebody picks a fight with you and you defend yourself and you win and that person leaves, the fight's over. You can't follow them back to their car. You can't continue to pummel them. Once the threat is over, then that's it. Physical force is no longer allowed. Now, a person may not use deadly physical force upon another person under circumstances specified in subdivision 1 unless, now here's where this is where we really need to focus. The actor reasonably believes that such other person is using or about to use deadly physical force. What do we consider deadly physical force? Now, I would say to you, as a former police officer, anything can be used as a weapon and can be used to kill you. So is a pen a deadly weapon sitting on the table? No, it's not. In the hands of somebody trying to jab it into your neck? Yes, it is. Are you authorized to use deadly physical force if somebody tries to jab a pen into your neck? Yes, you are. Because now the intent behind it is criminal. The pen itself is not dangerous until it's used in a dangerous manner. So if it's a bat, if it's a knife, if it's a pen, if it's a stick, if it's a gun, it doesn't matter. If it can cause serious physical injury, something permanent, something protracted, or death, you are allowed to use deadly physical force to defend yourself. Except a person may not use deadly physical force upon another person if the actor reasonably believes that such other person is using or about to use deadly physical force. Even in such case, however, the actor may not use deadly physical force if he or she knows that with complete personal safety to oneself and to others, he or she may avoid the necessity of doing so by retreating, except that the actor is under no duty to retreat if he or she is in his or her dwelling and is not the initial aggressor. So if you're out in public and you can retreat safely without getting shot or without getting somebody else shot, you should do so. If you can't, then you may defend yourself or another person. Now, you run away and this person gets shot because you ran away, even though you could have stopped it, then you're not following Article 35. You had every right to use deadly physical force to prevent deadly physical force being used against somebody else. Now, if that person runs away and they're no longer in danger and you can go without any danger, then you should. If you can't, I mean, turning around isn't going to be an option because, believe it or not, a criminal will shoot you in the back and not care. That's illegal. So I got news for you. They don't follow the law. That's why they're criminals. So just turning around and running away may not be safe. So don't assume that just because you can turn around and run away that you should. That may get you a bullet in the back. So, and you can justify that. You can articulate that. So now, if you're in your dwelling and you're not the initial aggressor, like you didn't invite the guy over to your house so you could kill him, which rarely happens, but let's say, then you would be in trouble. If you said, come over here, come to my house, and they come over, you invite them in, and then you kill them. You can't say, you broke in here, I feared for my life, and I killed them. No, you invited them over. You were the initial aggressor. This was your plan all along. But somebody breaks into your home, and you are in your home. You are not required to retreat from your own home. You can defend yourself. You can defend your family. If you reasonably believe and you can articulate that, you're going to be fine. I fired my weapon to stop the attack because I felt my life was in danger and I had a family to protect. So I did what I did to prevent him from getting my gun, getting at my family, whatever the case may be. However you articulate why you did what you did, because you can shoot an unarmed person in your house if you can articulate that he was close enough to grab your gun and possibly use it against you. And there are a lot of untrained people with guns who get their guns taken away from them very easily by somebody who is trained. And you military guys know, and those of you in law enforcement, how easy it is to take a gun away from somebody who is untrained. They don't know how to hold it. They don't know how to use it. They don't know how to keep proper distance for safety. So if you can get close enough to grab a gun, then you're in a deadly force situation, even if they're unarmed. Because once they get their hands on your gun, now they are armed. So that becomes a deadly force situation. A police officer, peace officer, or person assisting a police officer or peace officer at the latter's direction, acting pursuant to Section 3530. Okay, so what that means is if a cop says, I need you to assist me, and they're authorizing you to use deadly physical force, you are covered because a police officer or a peace officer, law enforcement officer, of federal, state, county, town, village, whatever, doesn't matter. If they authorize you to use deadly physical force, you're following a lawful order. You're covered. You're okay because they've ordered you to do so. It's on them now. If he or she reasonably believes that such other person is committing or attempting to commit a kidnapping, forcible rape, forcible criminal sexual act, or a robbery, and again, those are something that you want to look up the terms and know. A lot of people confuse burglary and robbery, and they are not the same. If you have a business and somebody breaks into it overnight when nobody's there and they steal all of your stuff, you weren't robbed. The place was burglarized. The only way for it to be a robbery is to physically take something from someone by force. So there has to be another person, a victim, involved. If you snatch a purse from a lady, that's a robbery. If you hold up somebody at a bank, that's a robbery. If you hold them up at the ATM, that's a robbery. If you reach into their pocket and grab their wallet, that's a robbery. If you break into a place and steal stuff, but nobody's there, that's not a robbery. So make sure you're familiar with these definitions and their meanings. You don't want to get them mixed up and intertwined because that could get you in trouble. You can also, if you reasonably believe that such other person is committing or attempting to commit a burglary and the circumstances are such that the use of deadly force is authorized by subdivision 3, section 3520, justification, use of force in defense of premises and in defense of a person in the course of a burglary. So, how that differs from a robbery is they are on a premise or in a building without permission. They're trespassing. Now they're intending to commit a crime, so now it's burglary. And now a person shows up. Now there's a victim. But they don't take anything. So it's not a robbery. But they remained unlawfully within this building premise or non-dwelling, because I'm going to get into that in a minute too, with the intent to commit a crime, regardless of what that crime is. And now there's a victim involved because there's a person there. So they don't have to physically take anything because it's not a robbery situation, but it is a burglary situation. And to prevent such burglary, you can use deadly physical force if necessary. So let's say you see that they have a knife. They break into the place and they start just doing criminal mischief. They're just damaging property, just expensive things they're breaking. They're not taking anything, but they're breaking things. So in order to stop that, you can use force. Now, if they're armed, or you have reason to believe that they are armed, or there's one of you and 6 of them, you may use deadly physical force in order to prevent. So again, it's all in how you articulate it. Did you fear for your life? If it's 6-1, yeah, I think you can get any person to reasonably believe that your chances of taking out 6 people with just your hands are slim and none unless you are very well trained. And there's very few people out there that are that highly trained that they can take out, 6 bad guys, at once. And not need to use deadly physical force. So you can articulate that. Now, persons who are licensed or privileged to be in the buildings or premises, but are not limited to. So that is somebody else owns the property, but put you in charge of it. It's like you own it. Police officers, peace officers acting in the performance of their duties, that doesn't apply to us. Security personnel or employees of nuclear powered electric generating facilities, that doesn't apply to us either. So we're going to skip over that. 3525. Justification, use of physical force to prevent or terminate a larceny or criminal mischief. Now, a larceny is a theft. Criminal mischief, as I said before, is damage to property, graffiti, breaking lights, busting windows, things of that nature, slashing tires. A person may use physical force other than deadly physical force upon another person when and to the extent that he or she reasonably believes such to be necessary to prevent or terminate what he or she reasonably believes to be the commission or attempted commission by such person of a larceny or criminal mischief with respect to the property other than premises. So if you're in charge of this building and somebody is committing a larceny or criminal mischief, you are allowed to use physical force in order to deter or terminate that incident, but not deadly physical, just physical. 3527. Justification, use of force in resisting arrest is prohibited. A person may not use physical force to resist an arrest, whether authorized or unauthorized. Now, that is important to remember. You may not have done anything wrong, but the cop doesn't know that when they arrive on the scene. So you may get arrested for whatever they're showing up for until they sort out who's who and what's what. So just because you didn't do it doesn't give you the right to fight the cop in the street and say, no, I'm not under arrest, I'm innocent, and, start putting your hands on them. You can't do that. You're going to get handcuffed, you're going to get put in the car, things will get sorted out, charges will be dismissed if there are any, you'll be released, nothing will go on your record if you were in the right. The minute you start to resist, you've already committed another crime, and that is going to be added to. And if you do manage to win the fight against the cop and run away, that is another crime. So that will be added to the list. And so for what you could have walked away from in an hour or two, you've just created two more crimes that you're not walking away from. So it's never a good idea to fight your case on the street. That's just never going to work in your favor, ever. So don't fight your case on the street, fight it in court. If you didn't do anything wrong and you get arrested, tell your lawyer, tell the judge, let the facts get sorted out, let the details fall, and then if it's serious enough to you, you might even have a case against the police department for an unlawful arrest. But if you resist, you've just thrown that out the window. It's no longer viable. You've just thrown that out. You blew that. So it's always best to just comply. People who comply don't get shot and killed in the street. So keep that in mind. But again, you can use deadly physical force to defend yourself or another person against deadly physical force. You are required to retreat only if it is safe to do so. If it is not safe to do so, or you're going to leave somebody else in danger, you are not required to retreat, because now you're leaving this person in danger of being killed. So if you're protecting this person and then you run away because you see an opportunity where he takes his eyes off you and puts them on her, and you run away, well, I mean, yeah, you can do that, but you're a coward if you do. You had every right to defend her, and you didn't. You were not required to run from that situation. Now, if she runs away and she's safe and he doesn't see you and you can just walk away because you haven't done anything, you haven't drawn your weapon yet, and you can walk away with no incident, then that's what you should do. Always avoid it if you can. But just turning around and running away is not necessarily the safest thing to do. And remember that you are not required to retreat from your own home. And if you're in your dwelling, and that's the difference. There's a dwelling, there's a business, and there's a premise, or the premises. A building may be a store, it may be a corporate office, whatever, a hospital, whatever the case may be, but it's not where you live. You don't reside there. A dwelling is where you reside. Where you live is your dwelling. So you're not required to retreat if you are in your dwelling or if you're in somebody else's dwelling. You've been invited to someone else's house. Something happens, somebody breaks in. You can defend yourself as well as the owner of the dwelling that you've been invited to, because under the law that is allowed. What you can't do is out, on a premise where, say, somebody committed a larceny and they're running through your yard. You can't shoot them for running through your yard, even though you know they committed a crime, because you're not in any danger. They're not harming anybody. They're running away. They haven't hurt anybody. They're not armed. That you're not in any danger. So even though they're on your premises, you cannot shoot them because they have not put you in any danger or anybody else in any danger. They're just trying to escape from a simple larceny, which is not allowed in New York State law. You're not allowed to use deadly physical force against. So I want you to look up those definitions. I want you to know the difference between robbery and burglary. I want you to know the difference between larceny, robbery. I want you to know the difference between dwelling and building. Arson is setting fire, and there's a difference between setting fire to an empty warehouse and setting fire to an occupied dwelling. There's different levels of felony there. So study that stuff, know that stuff. And again, when Matt puts out the PowerPoint presentation, go over the PowerPoint presentation. It's everything that I discussed here. Only now you'll have the background of knowing what the legal terminology really means, what they're saying. What constitutes this and what, and you may use only if, and you got to know, does this apply? Only if, okay, does it meet this criteria, this, and this? If it does, then yes. If it doesn't, then no, you can't. So it's something that, a simple look through the penal law book isn't going to be enough. If you want to be well trained and well, so that it's muscle memory when something happens, you got to go over it a couple times. You got to really spend time reading it, understanding it, and knowing it, so that when the time happens and the fight or flight kicks in and it's go time and you're going on muscle memory, that stuff should just be there. You shouldn't have to think, can't I, what was it, section 35 20, was that the one that said I did? You got to just know this stuff, because you don't have time to time out, Mr. Bad Guy. Let me look at the penal law book and see if I can shoot you. Yeah, apparently I can. Look at that. Huh. No, you don't. It doesn't work that way. So know this stuff. If you have any questions, ask. And obviously, keep training. Keep studying. Keep training. Make sure everything is second nature to you. When shit hits the fan and your brain goes into survival mode, your muscle memory should kick in. You're training anything that you've been trained to do, you will do. It will just be natural. And that's why we train, so that it becomes second nature. You don't have to think about it. You don't have to wonder. Any questions? Let me know. Thank you.